Okay. Hi everyone, very good afternoon and welcome back to CGB Mentors. So in today's session, we are going to talk about few of the MCQs on Negotiable Instrument Act 1881, right? Let us start. So question number 1 that we have is, which of the following is not a valid condition for a payment to qualify as payment in due course under the Negotiable Instrument Act, right? So over here they are asking you कि कौन सी इसमें से valid condition नहीं है payment in due course कहलाने पर. So number 1 is payment is made as per the apparent tenor of the instrument, payment is made to a person in possession, payment is made before the maturity date, and payment is made in good faith without negligence. So by reading this, you can clearly make out a difference that 3 pointers which are given over here, they are the valid condition. Payment in due course means it has been made as per the tenor of the instrument, it has been made to a person in possession and entitled for it, and over here the payment has been made in good faith. Making before the maturity date is clearly wrong, right? That would not be called as payment in due course, because payment in due course means you have made the payment when it was due, not before the maturity date, right? So see, it means payment made properly at right time, right person, be made on or after the maturity date, on or after, not before. Next, be made in good faith, honesty, without any negligence. So this is what we call as payment in due course. Next is, which of the following instruments can be crossed? कौन से इंस्ट्रूमेंट्स को क्रॉस किया जा सकता है? Promissory note, bills of exchange, checks, none of the above. So over here, remember that check as an instrument can be crossed, not promissory note, not bill of exchange. हम इनको क्रॉस नहीं कर सकते हैं. Fine. So crossing a check means adding 2 lines with the phrases like account pay only. This ensures that check can be deposited only in a bank account. It cannot be in cash. हम इसको in cash नहीं करा सकते, सिर्फ इसको deposit कराया जा सकता है. Next we have, what is the purpose of noting and protesting a bill of exchange? So they are asking you about the terms of noting and protesting a bill of exchange. Let us look at the option. To establish the drawer's identity, to secure payment from the payee, to legally record the dishonor of the instrument, and to apply for cancellation of the instrument. See, noting and protesting, it's a formal mechanism, right? So when there is dishonor of the instrument, when the payment has not been made on the instrument, you want to formally register your complaint, and this is what is associated with noting and protesting of a bill of exchange, right? So bill of exchange is not, if a bill of exchange is not paid or not accepted, holder can get it noted and protested. This creates a legal record that there has been non-payment on the instrument, and it helps us in filing a case against the person who has issued it. Now next is, when is presentment for acceptance necessary under section 61 of the Negotiable Instrument Act? ठीक है, when is the presentment for acceptance necessary? So over here, let us look at the option. For all types of promissory notes, for bills of exchange payable on demand, for bills of exchange payable after sight, for checks issued by banks, right? So over here, checks already have a date mentioned, ठीक है. Next thing is, here presentment for acceptance. This means this is in relation with when the bill of exchange is payable after sight. If it is a case on demand, अगर ये demand का case है, so in that particular case it would be payable whenever the other person demands it, right? There is no what you can say obligation for presenting the instrument so that it can get accepted. So कब आपको present करना पड़ेगा? Only when your bill of exchange is payable after sight. पहले आप show करेंगे, then a due date would be decided, and accordingly the payment would be made, right? Next, which of the following is not a valid condition for a payment to qualify as payment in due course under the Negotiable Instrument Act 1881? So over here, remember that check as an instrument can be crossed, not promissory note, not bill of exchange. So section 61, it specifies that a bill of exchange payable after sight must be presented for acceptance within a reasonable time and during business hours. Fine. If a bill is payable after sight, it means payment is due a few days after the bill is seen and accepted. पहले आपको bill देना पड़ेगा, then bill will be get accepted, and then a due date would be formalized for that. Next we have, which of the following statement is true regarding the presentment of promissory notes payable by the installments? ठीक है, promissory note payable by installment. So over here it must be presented 3 days after the due date of each installment. जब भी आपकी due date है उसके 3 दिन के अंदर अंदर जो है आपको इसको present करना है. Exact due date नहीं, because there is a grace period also which is attached. एक ग्रेस पीरियड होता है जो कि अटैच किया जाता है. सो इट शुड बी प्रेजेंटेड 3 days आफ्टर द ड्यू डेट ऑफ इंस्टॉलमेंट, राइट. Next you have, as per section 64, when is the presentment of a negotiable instrument for payment not required? कब आपको present नहीं करना पड़ेगा? So just now I have explained this to you. When it is payable after sight, when the drawee has no known place of residence, when it is a promissory note payable on demand, not at a specified place, and when authorized by a registered letter. So basically over here the correct answer is, कब आपको present नहीं करना है? When it is a promissory note which is payable on demand, as in when you demand it, you will get the amount, right? So in that particular case there is no need of presentment. So section 64, it contains an exception that if a promissory note is payable on demand and not at a specified place, then the presentment is not necessary to charge the maker. As per section 117, how is compensation determined when an endorser who is liable pays the amount due on a dishonored instrument? Endorser क्या होता है? Who signs it and forwards it. That means a party in between. Now suppose if because of any particular cause the instrument becomes instrument is not honored, right, and it is dishonored, in that case if the endorser makes the payment, what is the liability or what is the compensation he should be getting? ठीक है, क्या मिलना चाहिए? So only the face value, only expenses incurred, no, the amount paid, interest at the rate 18% and expenses, yes, that is recoverable. So if you are an endorser, you have been a party who has signed the instrument and have just forwarded it, and because of reasons you have to make the payment on that. So in that particular case you can recover your amount, whatever you have paid. You have recover interest at the rate 18% and any other expenses that you might have incurred. जो भी और भी जो खर्चे आपने किए हैं वो भी आप रिकवर कर सकते हैं. Next is, under what condition can a drawee bank demand the physical presentment of a truncated check? So basically what happens is, now for the clearing of checks, you don't have to supply the physical check. ठीक है, आपको physical check देने की जरूरत नहीं है. Just an image of the check is forwarded to the other bank and that is it. On that basis, clearing happens. But over here they are asking you, इन वॉट कंडीशंस, किन कंडीशंस में आपसे इमेज भी, आपसे ओरिजिनल चेक भी मांगा जा सकता है ड्रॉई बैंक द्वारा. Only if the check is dishonored, when the authorized by the payee, if there is a reasonable suspicion of fraud, forgery, tampering, destruction, if the check is of value above 1 lakh. So there is no value related conditions in this particular case. Only if the drawee bank thinks that there is a suspicion of fraud, forgery, tampering, etc. So in that particular case, they can ask the physical presentment of the check. Next is, presentment for acceptance or payment can be validly made to which of the following persons? Only to the original maker, drawer's employee, duly authorized agent, legal representative or assignee of an insolvent, endorser's bank only. See, whenever you are presenting for acceptance or payment, it could be made to the authorized agent, legal representative or the assignee of an insolvent. All these three designated people, they are allowed in case you are presenting a promissory note for acceptance or payment as per section 75 of the Negotiable Instrument Act. Quite easy to understand. Now, which of the following constitutes a material alteration that can void a negotiable instrument against a non-consenting party? So over here they are basically asking you that while preparing a promissory note, or once you have prepared it, after that what kinds of material alterations can make a negotiable instrument void. Void means now it does not hold any value in the eyes of law. So adding a memo line, correcting a spelling error, changing the place or time of payment without consent, attaching an additional stamp. See, in all these 4 cases, you can easily identify that what would classify as a material alterations. Basically, if there has been a change in place or time of the payment without consent, then that would be considered as a material alteration. ठीक है, उसको हम क्या समझेंगे? Material alteration. Next is, when does a banker not incur liability for receiving payment of a crossed check with defective title? Defective title का मतलब क्या होता है? If you have received it, but the other person who has given you the check was not having a good title, he was not a owner. ठीक है? So in this case, will the bank have any liability or not? Let's see this. So if the customer is a known defaulter, if the banker credits the amount after receiving payment, if payment is received in good faith without negligence, and if the banker is notified of a dispute. See, in the Negotiable Instrument Act, banks also have been provided with a safeguard. So over here, banker will not incur a liability if it has received the payment in good faith and without negligence. That means there were no visible signs of fraud or forgery, right? Bank has acted in a good faith, received the payment, right? And there was no negligence in the processes from the bank's perspective. So in such cases, the banker would not incur any kind of liability. Next is, what is the effect of a qualified acceptance without the consent of prior parties? Qualified acceptance का मतलब होता है that you have changed the terms and conditions without notifying the prior parties. ठीक है? So in that case, once you have accepted with qualifications, the other parties would also become liable for it. But here they are saved under the Negotiable Instrument Act, where it has been told that the prior parties would be discharged until and unless they agree for such a change. अगर वो agree करते हैं, then it's fine, they'll also be made liable. But if they do not agree, then they'll be discharged from the liability. तब उनको liability से discharge कर दिया जाएगा. Right? Next, what happens when a bill of exchange after negotiation is held by the acceptor in his own right at or after maturity? आपसे पूछा जा रहा है, if a bill of exchange after negotiation has been held by the acceptor, अब रख लिया है, आगे किसी को नहीं दे रहे हैं, so in this case bill will be dishonored, bill will become void, the holder may still claim, all rights of actions on the bills are extinguished. These are extinguished if the acceptor has kept it with him, is not forwarding it, right? So all the cases in the bill, that is now extinct, right? If the acceptor comes into possession of the bill after maturity, all rights on actions on the bill are extinguished because there is no third party left to enforce the payment, right? Next is, so I have added one more clarification over here if you want to read it. So the acceptor, one who agrees to pay, ends up holding the bill and he holds it as of his own, then the bill has served its purpose. Now he'll be liable and all the rights to sue or recover, they are extinguished. Now, liability of a person who signs and delivers an inchoate instrument is based on which particular principle? What is the kind of instrument is this? This is an incomplete instrument. And what are the principles? Bona fide principle, doctrine of ultra vires, doctrine of estoppel, principle of waiver. So over here the correct answer is doctrine of estoppel, and for this you have to go through this. If someone signs and gives away an incomplete instrument, they are saying, I trust the person to fill in the rest properly. Remember the blank check where I am leaving the amount column blank and giving it to the other person because I trust the other person will fill up the correct amount. Under the doctrine of estoppel, they cannot later deny their responsibility, especially if the instrument is the hands of a holder in due course. Holder in due course means ऐसा भुला भला इंसान जिसकी कोई गलती नहीं है, he do not have any kind of fraudulent intentions, कोई fraudulent intentions नहीं है. So in that case, once if you have given an incomplete instrument to somebody, later on you cannot deny कि भाई मैंने तो ऐसा नहीं किया. Next is a promissory note payable to order is negotiable only by mere delivery, oral consent, endorsement in delivery, physical possession of the instrument. Payable to order, how it is, how you are going to deliver it. So you can do endorsement and delivery. The spelling is wrong over here. Payable to order means you will sign it and you will forward it, right? So as per section 48, when a negotiable instrument is payable to order, both endorsements and delivery, they are necessary to effect the negotiation. Mere delivery is valid only for the bearer instrument. Bearer instruments, just like a note. Once you give it to somebody, they become the owner of it. But when an instrument is payable to order, not a bearer instrument, so you have to sign it and then give it to somebody else, and then they will have a good title for the instrument. So these were the questions that I wanted to discuss today for Negotiable Instrument Act. Please stay tuned for such more questions, and thank you so much for joining in.